S. Sahaj Vidhi www.sahajvidhi.in. Question 1. B. In breach of a sale contract, both the buyer and the seller have remedies against each other. Discuss the statement in reference to relevant provisions of the Sale of Goods Act, 1930. Model answer. The Sale of Goods Act, 1930, governs contracts for the sale of goods in India. Like any other contract, a contract of sale can be breached by either party, leading to various remedies available to the aggrieved party. The statement that both the buyer and the seller have remedies against each other in case of a breach is accurate and is well supported by the provisions of the Act. Remedies available to the seller when the buyer breaches the contract. The seller has several remedies, primarily aimed at recovering the price of the goods or damages for the buyer's non-performance. 1. Suit for price, Section 55. If the property and the goods has passed to the buyer, and the buyer wrongfully neglects or refuses to pay for the goods according to the terms of the contract, the seller may sue him for the price of the goods if the price is payable on a certain irrespective of delivery, and the buyer wrongfully neglects or refuses to pay, the seller may sue for the price, even if the property and the goods has not passed and the goods have not been appropriated to the contract. 2. Damages for non-acceptance, Section 56. If the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may sue him for damages for non-acceptance. The measure of damages is generally the estimated loss directly and naturally resulting, in the ordinary course of events, from the buyer's breach of contract. This is usually the difference between the contract price and the market price on the date of breach. 3. Remedies of an unpaid seller, Sections 45-54. An unpaid seller is defined as a seller to whom the whole of the price has not been or tendered, or when a bill of exchange or other negotiable instrument has been received as conditional payment, and the condition on which it was received has not been fulfilled by reason of the dishonor of the instrument or otherwise. Rights against the goods, even if property has passed to buyer lien, Section 47. The right to retain possession of the goods until payment of the price, if the goods have been sold without any stipulation as to credit, or if the goods have been sold on credit but the term of credit has expired, or if the buyer becomes insolvent. Stoppage in transit, Section 50. The right to stop the goods in transit and day paid. Resume possession of them as long as are in the course of transit and the buyer has become insolvent. Resale, Section 54. The right to resell the goods under certain conditions, such as when the goods are perishable, or after giving notice to the buyer of his intention to resell and the buyer fails to pay within a reasonable time. The seller can then recover any loss on the resale from the original buyer. Remedies available to the buyer. When the seller breaches the contract, the buyer also has several remedies, primarily aimed at obtaining the goods or compensation for the seller's failure to deliver or for defects in the goods. 1. Damages for non-delivery, Section 57. If the seller wrongfully neglects or refuses to deliver the goods to the buyer may sue him for damages for non-delivery. The measure of damages is the estimated loss directly and naturally resulting, in the ordinary course of events, from the seller's breach of contract. This is typically the difference between the contract price and the market of the goods on the date of breach. 2. Suit for specific performance, Section 58. In certain cases, where the goods are specific or ascertained and damages would not be an adequate remedy, e.g., unique artwork, rare items, the court at its discretion, direct the seller to specifically perform the contract, i.e. deliver the goods as agreed. 3. Remedy for breach of warranty, Section 59. If there is a breach of warranty by the seller, or if the buyer elects to treat a breach of condition as a breach of warranty, the buyer is not entitled to reject the goods solely on account of such breach. However, the buyer may set up against the seller the breach of warranty in diminution or extinction of the price. Sue the seller for damages for the breach of warranty. For repudiation of contract before due date, Section 60, if either party repudiates the contract before the date of delivery, the other party may either treat the contract as rescinded and sue for damages immediately, anticipatory breach, or wait until the date of delivery. In conclusion, the Sale of Goods Act, 1930, provides a comprehensive framework of remedies for both buyers and sellers to address breaches of contract. These provisions ensure that the aggrieved party can seek appropriate legal recourse, whether it is to recover the price, claim damages, or, in specific circumstances, compel performance, thereby upholding the sanctity of commercial transactions. They price may. Please visit our website www.sahajvidhi.in for more content.